The next case today is Maria S. Díaz-Báez et al. Versus Julio Alicea Vasallo et al. Appeal number 19-1474. Attorney Valenzuela, please introduce yourself for the record to proceed with your argument.
Good morning to all the members of the court. Good morning, honorable judges. This is Attorney Jose Enrico Valenzuela-Alvarado representing appellants plaintiffs in this case. May I proceed?
Please do.
Yes. This case deals with political discrimination, and it has two different areas that I will address here. First, the res judicata collateral estoppel issue, and second, the Mount Healthy defense. As to the first, we must first introduce the procedural background of this case as to the dates that finally render a decision of the Puerto Rico Supreme Court that the district court concluded that that decision precludes all the entire case through the summary judgment, and that's why we're here. So basically, this case was first filed on June 22, 2010. Thereafter, in November 15, 2012, there was a denial of plaintiff appellant's partial summary judgment. And in its denial, the court recognized that this case has a lot of controversy or issues of fact, and that it was a political discrimination case. So thereafter, in April 7, 2014, the court denied the appellee's defendant's motion for summary judgment, motion for stay of proceedings, because they asked the district court at that time in 2014 to stay the proceedings pending the decisions that were appealed regarding as to the hearing examiner or administrative cases, which dealt with the time computation for the dismissal. So at that time, that denial of stay was granted by the court. The court denied the petition of stay, and thereafter, on July 23, 2015, the court sua sponte asked for the parties to show cause why this case should not be stayed.
Mr. Valenzuela, yes. I think you can assume we're reasonably familiar with the travel of this case. But what interests me is the other side is claiming that it's been predetermined and is preclusive that the board had the only authority to make the final layoff decision and approve the layoff, and that therefore the agency itself cannot be liable. And yes. I know you dispute that. But what yes. I couldn't tell from your brief was, if we should agree that the board was the policy-making decision and the board made the decision here that's being challenged, and therefore you cannot sue the agency, is there anything left of your case?
Yes, Your Honor, precisely the case of Oppenheimer-Mendez versus Acevedo, which is 388 Federal Supplement 326, and was affirmed by the First Circuit Court. It recognized...
No. This case, is there anything left of your lawsuit that is now, if we make that finding?
No, I understand now your question, Your Honor. Actually, the case has been completely dismissed by the district court.
So you need to, if I'm following your brief correctly, you need to convince us that it's still an open issue as to whether the board was the final decision maker.
Yes, that's correct, Your Honor, because the case that I just quoted and that was affirmed by the district court, by the First Circuit Court, which is the Oppenheimer case, it clearly deals with that issue as to who's the nominating authority and recognizes that it's the executive director, not the board. And also, precisely the...
So the appellate court decision of Humberto Mueller versus AACA, why that decision was not appealed to the Supreme Court, which means that is the highest level court in Puerto Rico that has said, no, it's the board.
Yes, that's one of the arguments that were
Why aren't we bound by that?
Excuse me?
Why aren't we bound by that? That case dealt with most of these litigants, so it's not as if there were other people not involved. A group of the litigants here brought that Humberto case and lost.
Yes, because that case dealt with administrative proceeding as to the computation of the time when the time was approved by the board and executed by the executive director. So that issue was an administrative case.
5 minutes remaining. 5 minutes.
Dealt exactly or specifically as to the time, not as to the political discrimination arguments, which that's why we're here. And also, if we try to be some kind of try to understand the Mount Healthy defense, that is the second part of the argument, it has been included in Mount Healthy defense on jurisdictional grounds, and then why can be justified or explained that we have been litigating this case since 2010, and we're in 2021, and the case was dismissed in Mount Healthy grounds on jurisdictional issues that were supposed to be dealt in June 22, 2010, when the case was originally filed. So I did all the procedural dates. I explained that because precisely the district court rejected that argument when they issued the denial of the stay, and precisely because they understood at all time, as us also, that this case dealt with political discrimination. And even in the opposition for summary judgment to defeat the Mount Healthy defense, we even submitted 7 deposition or transcripts in summary, which are on the briefs, of direct, specific discriminatory intent and facts directly from Alicea Vasallo against these 7 individuals, which is very hard to believe that a state court can make the federal court to be preempted in the 1983 case, in the Section 1983 case. Precisely, the Section 93 case was created to avoid all these procedural difficulties and also to entertain the case faster when it has to do with the due process and First Amendment claims. So it is impossible to believe that a Supreme Court decided a case on the merits based only on a computation of time to conclude that all the other issues related to discrimination has been already also dismissed. So that's why we're here in general terms, and any questions that your honors might have, I'm here to answer all of them.
Okay, thank you.
You're welcome.
Are there any questions from my co-panelists? No. Thank you very much.
Thank you, Your Honor.
Attorney Valenzuela, at this time, you can mute your audio and your video.
Yes.
And Attorney Sanchez-Pagan, you can unmute your audio and video. You have a 7-minute argument, and you may begin by introducing yourself.
Yes, good morning, Your Honors. Afternoon for us. My name is Adrian Sanchez. I represent ACAA, which is the Automobile Accident Compensation Administration. I'd like to address real quick and just maybe clear some what I consider to be misconstructions of what actually happened. The Mueller case, which Judge Thompson asked about. The issue in the Mueller case was who took the adverse employment action against these plaintiffs' appellants. That was the issue in the Mueller case. And as Your Honor Kayara mentioned, you guys are, Your Honors are familiar with the procedural history. What happened is
That's okay, Mr. Sanchez. We've been called guys all of our life, regardless of gender.
Well, I mean, but I
All
apologize
right.
for the informality.
Yeah, you will henceforth refer to us as judges, okay?
Yes, Judge Cayera.
We understood that as the generic, you guys.
Yes, I did not attach anything with regards to gender in that expression. So, but anyway, putting that aside, what happened in this case is that as soon as this layoff plan was implemented or started to be implemented, actually, the challenges in the state court began right when the rumors that it would begin to be implemented began. And what happens is that almost all of the appellants challenge many aspects of this plan in state court. And also this other group of 62 plaintiffs filed the 1983 claim in federal court. But while the 1983 federal claim was being litigated, so were the state claims. And what happened was the Mueller case was actually brought by 27 of the actual appellants in this case. And they actually won that case. Their argument was that the body or entity or individual that took the adverse employment action against them, meaning approving the layoff plan, the date, the cutoff date, and the 9-year seniority, as well as the list of those who would be terminated, was the board of director, not the executive director. And actually they won. The Court of Appeals ruled in their favor and said it was board of directors who took the adverse employment action. Now, why was that issue important? Why was that brought? Because during after they were notified of the intent of termination, they had a right to appeal to ACAA's administrative judge. And ACAA's
4 minutes remaining. 4 minutes.
Thank you. And ACAA's administrative judge jurisdiction is limited only to reviewing the acts of the executive director. So it was important to find out who took the adverse employment action, because if it was the executive director who took the employment action, then the administrative judge would have jurisdiction to revise the acts of terminating these employees. But the Court of Appeals said no, it was the board of director. And actually, again, it gave appellants the reason. Appellants were the one who were sustaining this position. Now, today, in this case, when the district court, based on that ruling, which became final and firm, nobody appealed. But also, what is interesting is that through the administrative appeals process, some of the appellants raised the issue again. And in a separate case, it went to the Supreme Court of Puerto Rico. And the Supreme Court said, this issue has already been resolved by the case in Mueller. And it was the board of directors who took the adverse employment action. So when we plug in that fact in this 1983 case, which requires the plaintiff to prove that the individual that took the adverse employment action did so for political reasons. But what happens in this case is that when you try to plug in that it was the board of directors who took the adverse employment action, what happens is that they're not sued in this case. They're not a defendant in this case. There's no allegation in the complaint that the board of directors or any of their members knew what the political affiliation of the plaintiffs were, and there's no allegation that the members of the board were also of a different political affiliations, and there's no allegation that the reason or the substantial motivating factor behind the board taking that adverse employment action was political. And I will add, the district court not just ruled based on the Mueller case. The district court had before it the entire record. The district court had financial statements of ACAA. The district court had years of minutes from hearings from the board. And in those minutes, independently, regardless of what the Mueller case ruled, just by reading them, you know that ACAA had been since at least 2006 considering a layoff plan. And 2006 was the other administration, was the PDP administration, wasn't the NPP administration. So the bottom line is, yes, the ruling in Mueller and the Supreme Court is controlling as to an issue. It is not controlling as to the 1983 claim, but that's not what the district court said. The district court said it is controlling as to an issue that is material to the 1983 case, namely who took the adverse employment and action. And then second, it didn't just stop there. If you look at the statement of uncontested material facts, the district court goes over those minutes, goes over the financial records, and nobody has ever been able to dispute that ACAA was in a dire financial situation. Whether they should have picked 13 years and fire everybody that had been hired in the last 13 years or 9 years, that was a decision the board made. Yes, the executive director did in some ways advise the board as to how to gauge or organize this plan, but it did so under the instructions of the board, and those minutes reflect that. So it's not just the Mueller case, not just issue preclusion that moved the district court. It was actually the independent record, and also the lack of concrete allegations on the part of the plaintiffs, number one, regarding issues with political affiliation with the board. And even so, I deposed all the plaintiffs. Only 2 or 3 could say
Time has expired.
Yes.
No, thank you, counsel.
You're welcome, Your Honor.
At this time, Attorney Sanchez, please mute your audio and video. Attorney Mundere, you can begin your 3-minute argument by introducing yourself on the record. Thank you.
Yes, may I please the court? My name is Francisco J. Amundaray Rodriguez on behalf of Julio Alicea Vasallo. Your Honor, this case is quite simple, and I think that each and every one of you understands what's at issue in this case. It's who made the final decision, who was the final decision maker, and that was the board of directors. That's not only that is not only something that was resolved by the Court of Appeals of Puerto Rico.
Ms. Mundere, I don't think that's the issue. I think the issue is whether collateral estoppel and res judicata applies to that determination.
I understand that it does, Your Honor. It has there is issue preclusion here, but there is also evidence in the record, Your Honor, that unequivocally tends to indicate that the final decision maker was the board of directors and not Mr. Julio Alicea, and plaintiffs have not been able to refute that.
Well, in fact, your opponent conceded that his case disappears if we affirm the collateral estoppel and res judicata findings of the district court, who looked at what the Puerto Rican courts have done, both the appeals court and the Puerto Rican Supreme Court. So does that leave you with anything else to say?
No, Your Honor.
Okay, well, thank you very much.
It has been my pleasure.
Thank you.
Thank you, counsel. That concludes the argument in this case. Attorney Valenzuela, Attorney Sanchez, and Attorney Mundere, you should disconnect from the